I give the call to the member for Warringah.
Thank you, Madam Deputy Speaker. And I rise to speak in support of the National Anti-Corruption Commission Bill 2022. And I move the amendment as circulated in my name, the amendment moved by Mr Wilkie to the second reading amendment moved by Dr Ryan, that the following words be added after protections and 3. Note that the exceptional circumstances requirement for hearings to be heard in public is likely to lead to very few investigation hearings being held in public and is not in line with the public expectation of increased accountability and transparency. This bill goes a long way to addressing one of the most important issues influencing the shape of Australian politics today. The crossbench has long campaigned for prioritising a Federal Integrity Commission, and I'm glad that the government has made good on its election promise to create such a body, and to ensure both that it has teeth and that it will have the power to investigate retrospectively. We need this bill because, at present, and the National Anti-Corruption Commission, the closest thing we have to an Integrity Commission is the Auditor-General's Office, a body in the past few years which has questioned a long list of scandals, including car park rorts, sports rorts scandal and the Leppington land sale of Sydney's second airport, to name just a few. As a result of these scandals, public trust in Australian politicians and in our democracy is declining at a rapid rate. We need a National Anti-Corruption Commission to uphold standards of integrity and demonstrate that our democracy is robust and people can trust us. Importantly, this bill has the potential to create a serious National Anti-Corruption Commission. It will have broad jurisdiction to investigate public sector corruption. It will provide for prevention and education to bolster anti-corruption measures, and it will have retrospective powers. It will have the ability to hold public hearings, although limited, and as such the reason for my amendment, and have the ability to initiate its own investigations and take referrals from the public and the parliament. It will be overseen by a parliamentary joint committee and inspector. It's a good bill, but it can be improved. The crossbench are again leading the charge to make this bill better. In several respects, I believe it does not go far enough, and I will speak to these areas where I believe it is deficient. There are several issues. The first, and I believe the most critical, are the limitations on public hearings, the definition of corrupt conduct and the identity of the chair of the Parliamentary Joint Committee. I'm also concerned about the independent funding for the Commission and the absence of Whistleblower Protection Commissioner. These two issues are far-reaching and important and will probably need to be the subject of separate legislation, but I want to flag that without them, I consider the proposed Commission comes up far short. I'm also concerned about referrals from Parliament, the need to set parameters for the timing of reports to ensure that the Commission hands down reports in a timely way and that legal professional privilege and opportunities to respond to findings of corruption. Opinion polling and public commentary, as well as electoral trends, all indicate that the public feels strongly that legislation of this kind is needed. The government, in its explanatory memorandum, states that the NAC bill would strengthen corruption prevention across the Commonwealth Government by enabling the NAC to undertake public inquiries and provide advice on corruption risks and vulnerabilities and strategies to address them. These aims are laudable, but I think the government's bill fails in three major respects to achieve this. Firstly, I consider that corruption prevention is seriously constrained by forcing the Commissioner to limit public hearings to where he or she decides there are exceptional circumstances. There are three main objections to the inclusion of this threshold. Firstly, the word exceptional is an uncertain requirement, which would encourage challenge in a court of law. And I agree with the Centre of Public Integrity that this could be exploited by well-resourced litigants to both delay Commission investigations and to obtain knowledge of the material that the Commission has against them. This is hardly likely to strengthen corruption prevention, using the government's own words. Secondly, no other Australian jurisdiction has adopted this approach other than Victoria. And there, in its submission to the parliamentary inquiry, the Victorian IBAC has stated that it believes that this is an unnecessary hurdle which has hampered the Victorian IBAC in carrying out its role. The IBAC submission pointed out that the Victorian Court of Appeal has determined that for circumstances to be exceptional under Section 117 of the IBAC Act, they must be clearly unusual and distinctly out of the ordinary and compared with the allegations of corrupt conduct ordinarily investigated by IBAC. This has had the effect of placing an artificial limit on IBAC's ability to conduct examinations in public. Thirdly, if the concern is that the public hearings may unfairly damage a person's reputation, I would point to the proposed Section 73 of the bill, which already lists amongst the matters which the Commissioner may take into account in deciding whether to hold a hearing in public, that any unfair prejudice to a person's reputation, privacy, safety or well-being that would be likely to be caused if the hearing or the part of the hearing were to be held in public. So, having taken this into account, I strongly agree with the Centre for Public Integrity that having to consider where there are exceptional circumstances on top of that, on top of the public interest, is an unnecessary and inappropriate further hurdle. Secondly, I have serious concerns about the definition of corrupt conduct. I support the amendment proposed by the member for Indi, namely to the effect that corrupt conduct is also any conduct of any person, whether or not a public official, that impairs or that could impair public confidence in public administration and which could involve any of the following matters, and which goes on to list a number of matters. I strongly agree with the Centre for Public Integrity that without this additional wording, the legislation would be inferior to that of all other Australian jurisdictions other than WA and Tasmania. So I note that the government has said that other conduct that could adversely affect public administration, such as external fraud, will continue to be dealt with by existing integrity agencies, such as the Australian Federal Police. However, I agree again with the Centre for Public Integrity that focus on individual criminal acts and actors may cause an anti-corruption commission to miss the forest for the trees and may therefore mitigate against strengthening corruption prevention, the very lofty goal of the government's own explanatory memorandum. Thirdly, I'm very concerned at the fact that the chair of the Parliamentary Joint Committee must be a member of the government. Since the chair will have a casting vote, I'm concerned about the effect on the independence of the committee. I believe that the chair must not be a member of a political party that forms part of the government, and I support the amendment proposed by the member for Indi to that effect. This is an opportunity for the government to be bigger than politics. With all the rhetoric and all the words that have been said in the public domain about wanting to improve trust in government and improve trust in politics, this is the opportunity to truly be multi-partisan and truly establish a joint committee that will ensure independence. It is so incredibly important for the Australian public to have trust that this is done to the utmost degree. And here is an opportunity for the government to step up to the plate. Next, I turn to the two issues where I mentioned earlier are also of great importance, which are the wide-ranging implications and which justify consideration for separate legislation. Firstly, the need for independent funding of the Commission. While I note that the Parliamentary Joint Committee must report to both houses of the Parliament on whether the Commission has sufficient funding and whether its budget should be increased, I agree with the Centre for Public Integrity and other members of this place that this gives no long-term security for the Commission. The Centre has proposed a model which would set up an independent funding tribunal which would oversee the annual budgets of key accountability institutions, including the Commission. I commend the work done by the Centre in this respect and consider that this proposal should be the subject of separate and more detailed consideration by the Parliament. Secondly, the need for a whistleblower protection commissioner. I welcome the fact that Part 5 of the bill allows any person to refer a corruption issue to the Commissioner, and that under certain circumstances, heads of Commonwealth agencies and intelligence agencies must refer certain corruption issues to the Commissioner. However, I note that the anti-corruption bills introduced by the crossbench in 2018 and 2020 and the member for Indi would have established a whistleblower protection commissioner. Such a body is absent from the government's draft legislation. I refer to the joint statement of support for the Commission signed by myself and 14 other crossbenchers in its call that the bill should include provision for a whistleblower protection commissioner. Given that the bill fails to do so, I believe that this should be further addressed and discussed by the Parliament in separate legislation to be considered and proposed. And finally, there are other issues in which they will be proposing amendments at consideration in detail stage. In summary, these are, firstly, that the Commission should be obliged to deal with corruption issues referred to it by the House of Parliament. This would be an exception to the discretion which the Commissioner would otherwise have as to whether or not to deal with corruption issues referred to it. This is a place where we represent our communities and the Australian people, and if a matter was determined in this place to need to be investigated by the Commission, I believe it is appropriate that that should occur. Secondly, I believe that the Commissioner should have discretion in deciding whether or not to hear in private evidence that would disclose legal advice or communication protected by legal professional privilege. I agree with the Centre for Public Integrity that to make this mandatory would be to leave it open to well-funded litigants to exploit this right with the effect of delaying or disrupting the Commission's work. Thirdly, I believe that there must be a time limit on the opportunity for a person or entity the subject of a critical finding by the Commission to respond to that finding. Currently, it's stated to be a reasonable time, but I think that this should be changed to 3 months or such longer period as is determined by the Commissioner. We should not have a situation where persons investigated indefinitely delay the conclusion of an investigation by not providing that response. Lastly, I believe the provisions relating to the requirement for and timing of tabling of investigation reports in Parliament, where public hearings have been held in respect to that investigation, should be extended to all investigations and where the hearings have been held in public or private. The Australian public wants to know if investigations are being held, and they want to know the outcome of those investigations. At the moment, there is much too much provision in this bill that keeps it behind closed doors and provides a whole different standard for politicians than the rest of the public gets. There should also be a time limit of 12 months for the tabling of a report after the last hearing is held. Because as we see in numerous jurisdictions, and I look at the New South Wales where it's been over 12 months without any report in relation to the investigation into the previous Premier of New South Wales, reporting delay leaves a cloud of uncertainty over a person for an unreasonable amount of time. And I think it is incredibly important that the legislation provide direction and a time limit of 12 months for the tabling of such reports. Ultimately, I strongly support the establishment of a National Anti-Corruption Committee. Along with many members of this crossbench and of this parliament, we know the public have had enough and they want to see government, politicians and third parties held to account. I strongly urge the government to consider the 2022 election outcomes and the strong community support for returning integrity, accountability and transparency to government. This can be done by accepting amendments to propose to better this legislation. Otherwise, it's disappointing. It's a good bill, but not a great bill, and one that may well fail to deliver what Australians so clearly want, a return to transparency, accountability and integrity in Australian politics.